Good morning, members. This is the Subcommittee on Hong Kong Civil Aviation Investigation of Accidents Amendment Regulation 2017 and Air Navigation Hong Kong Order 1995 Amendment Order 2017. We now call the meeting to order. First of all, let's elect the chairman. Members, any nominations, please. Ms. Tanya Chen. Good morning. Please switch on her mic. Good morning. I nominate Mr. Jeremy Tam. Do you accept the nomination? Yes, I do. I second. So you accept the nomination. Do I hear any other nominations, please? No? Well, in this case, I would declare that Mr. Jeremy Tam has been elected as the chairman of this subcommittee. So, Mr. Tam, please come forward to take over the chairmanship. Good morning. I would like to invite the public officers to join us. Good morning, ladies and gentlemen. We have already got a list of attendees. I'm not going to introduce you one by one. First of all, I give the floor to Mr. Wallace Lau. Please brief us on the paper. Thank you, Mr. Chairman. Good morning, Mr. Chairman. Good morning, members. The administration would like to amend the Hong Kong Civil Aviation Investigation of Accidents Regulations. Would like to set up an independent air or aviation civil aviation accident investigation so as to meet the requirements of ICAO. In November 2016, ICAO introduced a new requirement asking all the contracting parties to set up its own independent civil aviation accident investigation authority. It should be separate from the aviation authority so as to ensure its neutrality. It is expected that by October 2018, the initiative should be put in place so as to meet the latest requirement. Currently, in Hong Kong, if we have a civil aviation accident or if we have civil aviation accidents involving Hong Kong aircraft, the CAD is responsible for the investigation. We've been following the standards and recommended practices of the ICAO. They've always been up to the standards of the ICAO. Now, the Chief Inspector has always been the Director General of Civil Aviation. We have always been upholding the neutrality, but then from time to time, we may need to look at the functions of as well as the services provided by the CAD, say, for example, air controlling services. So the current arrangement may not be perceived as absolutely neutral. It may not be in line with the requirement of the ICAO. We'd like to set up such an independent authority. This is because we have the responsibility to meet the latest standards and requirements of ICAO. Having having taken into account the overseas experience, would like to set up an independent air accident investigation authority under the Bureau so as to take over this function of the CAD, and it will be led by one chief officer and to be assisted by 6 other officers. They will be appointed by the CE, and they will be directly responsible to the CE. Would like to set up such an independent authority so as to preserve the impartiality and credibility of the investigation findings, so that we can finalize the investigation early and learn from the investigation. We can also enhance the safety management and accident prevention initiatives. As to the details, in order to allow the chief inspector and the investigation team the statutory powers, we'd like to amend the Hong Kong Civil Aviation Investigation of Accidents regulations, so as to spell out clearly that the power of investigation is vested in the THB, and then the team will be led by the chief investigator. Moreover, for the powers given to the Director General of Civil Aviation will all be transferred to the chief investigator. As to what should fall within the ambit, I would like to refer to Annex 13 to the Convention on International Civil Aviation, so that we will also include the definitions for accidents and serious incidents, so as to clarify the scope of investigation. And then if we have any civil aviation incidents, that is non-accidents, non-serious incidents, they can still be looked into by the chief investigator. Between 2018-19, that is, we are going to move amendments to other parts of the relevant legislation. We hope that members will support this amendment regulation so that we can catch up with the latest ICAO standards, and then we can enhance aviation safety, and we can also maintain our status as an international aviation hub. Thank you. Members, if you've got any questions concerning the policies, you're welcome to raise them. First of all, Mr. Wu Chi-wai, 4 minutes. Regarding the regulation itself, I don't have strong views, but then recently at the ESC meeting, we also talked about the establishment of this investigation office. In the future, the commissioner I would like to know about the powers given to the chief investigator. And the powers can only be exercised in relation to accidents or serious incidents, that is, personal injuries or aircraft being damaged. Earlier on at an ESC meeting, we were asked to grant the establishment proposal. It appears to me that that paper is different from the current proposal. For that paper, it covers quite a lot of issues. So my question is, for you to set up the independent accident investigation office, what sort of powers can be exercised by the head of this office? Would it be confined to the provisions under this regulation? What about issues outside the scope covered by this regulation? Can the chief inspector do this? Can he rely on other tools? if he does exercise such powers, does it mean that nobody may refuse to provide the information? I think this is the first point that I am interested in. Regulation 585 says that he can have some preventive concerns. That is, in order to prevent future major accidents, he may start an investigation. But then I don't see such an implied meaning elsewhere in the regulation, because it appears to me that his powers can only be exercised over the investigation of accidents and serious incidents. So in the course of the investigation, when he's faced with scenarios like Regulation 585, what sort of powers is he entitled to? Will he be given sufficient powers under this regulation? And I want to know whether the administration can make sure that the commissioner or the chief inspector can really carry out his work. Mr. Lau, I'll try to take a broader view when I answer this question. Then I will be specific about Mr. Wu's questions. Well, first of all, we would like to amend the regulations. I'm sure you understand that at the FC, we are getting the money to recruit this post of chief inspector. There's only one single goal, that is, we want to be unbiased, we want to be independent, and the office will have sufficient powers. Both the office as well as the chief inspector will have sufficient powers. In other words, we have to facilitate the chief inspector as well as his team so that he can carry out the investigation. As to the point raised by Mr. Wu, accidents and serious incidents, indeed, both have been clearly spelled out in the amendment regulation. Actually, we are applying the definitions in N13 to our our amendment regulation. As to incidents outside the scope of accidents and serious incidents, Regulation 585 thus says that if the chief inspector thinks that there are incidents that are of reference value, he may start an investigation, and he can exercise his powers, ask for statements to be taken, and he can enter certain premises to carry out investigations. In other words, a chief inspector can be given the powers and he can exercise them instantly. And then for Regulation 9, as it stands, for the tier under the chief inspector, we have already said that he can refer to any accidents or incidents, say, for example, minor issues affecting the operation of aircraft will also be covered. Mr. Wu wondered whether we should also have a clear or statutory definition of incidents. Well, I think the current regulation has already given ample powers to the chief inspector. But I'm sure Mr. Wu's point can be followed up in our second round of review. That is, as I've mentioned in the session 2018-19, we'll come back to the electrical, and that point can be taken up there.
Chairman, I think that for this independent chief inspector, he's more or less like an ombudsman. And for an ombudsman, a piece of legislation will give him clearly stated powers concerning investigation, and as a result, other departments cannot resist. However, for this piece of legislation, I think the powers given to the CI are a bit limited, because you are just confining the scope to accidents or serious incidents. If it does not belong to this category, well, I'm sure that CAD will be quite compliant. However, in terms of law, I don't think it's comprehensive enough. Mr. Yu Si-wing. Thank you, Chairman. Now, the ICAO has adopted this new measure, and each country would have its own way of doing it. In the past, the Director General of Civil Aviation would take up the post of the CI, and now you want to set up an independent authority. Now, for Hong Kong's aviation sector, I don't know if you have consulted it. And also, just now we talked about the definition of accidents and serious incidents. So with these amended regulation, will there be a difference with the old definitions? And for the worker flow, there will be changes, because in the past the CAD would do the investigation, and now there will be a new investigation authority. So for the terms of reference, will they change? And for an airline, when it comes to its practices, would there be changes? Would there be major changes in the whole system? So can you tell me more about all these? Well, I'll ask Mr. Yu's first and third question, and then Mr. Shan will answer the other questions. As for public consultation, Mr. Yu can rest assured in March and April of 2013, with regard to the setting up of this independent investigation authority, we already consulted the aviation sector, including airlines, helicopter operators, pilot associations, and also we have a Aviation Development and Three One-Way System Advisory Committee. We also consulted it, and we've got clear support from all these stakeholders. That is, they all support the setting up of the investigation authority. So for this whole concept is supported by the whole aviation sector. As for the third question, when it comes to terms of reference, well, there will not be major changes. The only change that is, well, now at present, the Director General of Civil Aviation will take up the post of the CI. In the future, the CI will be an independent person, and he's accountable to the Secretary for Transport and Housing. However, in other areas, concerning terms of reference, etc., there will not be any major change. Next, Mr. Sam, about the definition of accident and serious incident. Well, for accidents and serious incidents, our change this time is to make sure that we would comply with Annex 13 of the Convention of International Civil Aviation. As for the original Chapter 448B, we have definitions, and those definitions are quite similar to the new definitions. Well, our laws have not changed for a number of years. However, the ICAO would update its practices and legislation every year. So this time around, we are just making a little bit of change. And you asked just now, well, for an airline, whether it would have to change anything after the regulation is amended. I don't think so, because for this time we are just changing the CI. That is, the powers of the Director General of Civil Aviation would be given to the CI. And if there's an incident and the relevant airline would have to report to the DG of Civil Aviation, there's no change, because this time around we are focused on accidents investigation, and there are clear definitions in the law as to what is accidents investigation. Mr. Kenneth Leung. For THB, on the 7th of this month, it gave us a Legislative Council brief. And for paragraph 19, it's about the financial implications. And each year there will be an extra cost of $9.628 million. That includes the CI, which is pitched at D2 level, and there will be 5 additional non-directorate posts. For this D2 CI, if we look at its rank in the government and compare it with other similar posts in other countries, is it higher or lower? And also for the 5 additional non-directorate posts, what are they? Thank you, Chairman. For the D2 level, it's very difficult to make a direct comparison because for each country and place, they have their own systems. When we look at the D2 level work experience, requirements, and background, etc., we think that is quite similar to other comparable countries, such as the UK. Now, in our paper, we state that this post will last for about 3 years, and after the work starts, we will accumulate experience. Now, we will try to find out that whether a D2 level officer would be enough to carry out such a job. And after the 3-year period, we will think about the next step, and we may come back to LegCo to ask for the setting up of a permanent authority. So we will learn from the 3 years experience, and we will submit another proposal to the LegCo. As for the other 5 non-directorate posts, well, actually there are 6. And they will be divided into 3 designated teams, and each one will be headed by a senior operating officer, or senior operations officer. 3 senior operations officers and 3 operations officers. So for each team, there will be 1 SOO and OO. So they are all professionals and licensed. They have the license to carry out investigation, right? Mr. Sham can give you more details. Now for these 6 colleagues, we require them to be adequately experienced. For CAD's investigators, they have the original or professional works. For example, they may be in air traffic control, they may be pilots, they may be looking at airworthiness, etc. The inspectors would also have to undergo relevant experiences. Now we will send them to Grenfell College in the UK for 6 weeks to take such a course. And then they would have to do certain investigations before we can have them qualified. As for this newly established authority, our requirements are more or less the same. So internationally, is there a qualification for air accident investigators? In other countries, in the UK, the US, and Australia, and France, they already have their own investigation authorities. However, they do not issue a license for the investigators. Well, for paragraph 20, you say that the proposal has no economic, productivity, sustainability, environmental, family, and gender implications. So for this new authority, will you have female staff members? If you tell me that they will all be men, then maybe you should consider a more balanced approach. Paragraph 20 is a basic phrase for electrical papers. It's like a template. So we will be looking at the experiences of the staff. As for their gender or race, they are not our considerations. I know that you have already briefed members, and you are saying that for the CI, you will be recruiting globally. And now it's pitched at a D2 level. Will the remuneration be good enough to attract people with the right caliber? Because they have to relocate to Hong Kong, and Hong Kong's rent is so high. They may have to spend half of their salaries on renting a place. So will you be providing accommodation subsidy to the CI? Can you speed up, please? Yes. Yes, we are confident that we will be able to hire a person with the right caliber. Of course, remuneration is one of the considerations. However, in this sector, I believe a lot of people are willing to come to Hong Kong to work because Hong Kong is an international aviation hub. We have different types of aircrafts, and in the Pearl River Delta airspace, there are a lot of challenges in terms of work. So I believe certain professionals would like to come to work in Hong Kong because they will gain a lot of experiences, and when they go back home, they will be considered highly. As for the cost on staff on cost, on average is $2.8 million for this post. So when it's compared with the UK and Europe, this position's pay is quite attractive. Any other questions? Mr. Yu Siwing. Now for this regulation, now we're going to amend it. Do you need to inform the ICAO, or all the countries are just legislating by themselves and then they just inform the ICAO? If that is the case, will there be differences among different countries? And as a result, when it comes to implementation, there will be discrepancies. And also about the staff. And for the CI, would or does ICAO have any requirement for the qualification of such a person, or each contracting state will recruit its CA on its own? Otherwise, in different countries, the chief investigators may have different terms of reference, because this is, after all, a new approach which has just been introduced for 2 to 3 years. So in the future, when there is an accident investigation, you may have to do things very urgently. For example, an aircraft is missing and passengers are missing. So for this D2 position, when it carries out investigation, some other countries' authorities may think that this position is too low and they do not want to cooperate with our investigator. Would there be such problems?
Mr. Shum, thank you, Mr. Yiu, for your question. Well, Annex 13 of the ICAO has already made it clear That is, if it meets the definition of accidents and serious incidents, then an investigation has to be carried out. The place of the accident or the incident has the duty to inform the ICAO, and then the state of registry, the state of design, the state of manufacture, etc. should all be informed. Similarly, if a Hong Kong registered aircraft is involved in an accident overseas, then the corresponding authority has the duty, in accordance with ICAO standards, inform our investigation office. As to your second question, as to the requirements, first of all, for the Chief Inspector, of course, it will be appointed by the relevant government, and the respective governments will consider the requirements concerning qualifications, ranking, etc. Nobody would query as to the Chief Inspector involved. That is, whether he is experienced enough or he has got the right qualifications. At the time when liaison is needed, we'll certainly respect each other's chief inspectors. I want to know whether you need to notify the ICAO or whether you need to require approval of ICAO, or whether it is a matter of you do it and then it's fine, or do you need to report it to the ICAO? Whenever there is a investigation, you need to notify the ICAO. No, I think Mr. Yu is trying to know, as far as your organizational structure and your post is concerned, do you need to inform the ICAO and ask for its approval? No, there's no need for that. But ICAO has said that if there is a deviation from the standards, then the ICAO has to be notified. As to the post holder as well as the establishment of the organization, there's no need to inform the ICAO. So I want to know whether you need to you need to get approval from the ICAO. Otherwise, if it is not up to the requirements, we endorse the regulation, and then the ICAO says that we are having too stringent requirements and other contracting parties are not able to meet our requirements. So I want to know whether you need to have some communication with the ICAO first. Well, to give a brief reply to Mr. Yu, we don't need to notify ICAO because we don't need the approval of ICAO as to whether our regulation can meet the requirements. Well, ICAO has merely given out the basic requirements, and then organizations, governments are formed differently. All they're asking for is to have an investigation authority segregated from the aviation authority, so individual parties are allowed to go ahead with their arrangements. For the first round, I think it is my turn to ask questions, and I've got quite a large number of questions. Well, for the investigation office to be set up, and you are going to define accidents and serious incidents, and they will be responsible for the investigation. But how do they know about them? Currently, there will be an MOR, and mandatory report to be written up concerning an accident or a serious incident. When it's seen that it is serious, and then the CAD would start an investigation. Now, once this office is set up, where will the MOR go? Going to the CAD first, or whether it will go to this independent authority, or whether it's a case of the MOR being sent to both organizations? Well, to give you a brief reply, our idea is that once the chief inspector has been appointed, then we will study the relationship between the CAD and the Accident Investigation Office. They can sign a memorandum so that we can clearly provide for the detailed arrangements so as to prevent misunderstanding. You refer to the example of the MORs. Our current thinking is that for this chief inspector who is independent, he must have unfettered access to such information. If he has to read such documents, nobody can or should prevent him from doing so, and nothing should be withheld from him. For the MORs, we hope that they will be delivered to both organizations in parallel. In other words, if the chief inspector thinks that the matter can be referred back to the CAD for follow-up, is fine. However, for one or two incidents or accidents, if the CI would like to look into them personally, or if he thinks that there are lessons to be learned, he can also take the initiative to look into such investigations. So the CI will can take the initiative to do so. After appointing the chief inspector, we will have a meeting among the CAD, the chief inspector, and ourselves. But the concept you referred to will be implemented. Now we're going to get this independent authority. It has to advise the THB as to what should be enhanced or improved in the light of the accidents or the serious incidents. Now, they may only be looking into one or two such cases. There was this query as to whether it would be necessary to have a full team of officers being on standby the whole year. Of course, we do have some accidents or incidents, but we do hope that in the future the number will be 0. Now, since they will be having access to the MORs, I want to know whether it is right to ask them to come up with a report, not so much on the one or two cases that they have to look into, but would it be a good idea to come up with a sort of overall report and classifying the incidents and accidents? Well, my short reply is that we do expect them and we do hope them to do so. Their work isn't just for the sake of themselves or for the THB. We want to find out about the causes of the accidents or the incidents, and we think that the findings should be made known to the industry. In other words, the office must have a lot of communications with the industry. For each and every case, of course, the report will be published. As to whether there will be a yearly report talking about the lessons to be learned, we also hope that the office will be forthcoming. So once the CI has been recruited, we'll try to see whether there will be such a yearly report in its annual plan. Say, for example, the findings, new information, etc., to be shared with the industry. All right. Any other questions from other members? If not, then I want to get down to my second round. I have received a letter from the Association of Hong Kong Air Pilots. I think they have emailed a copy to our secretariat. I think, first of all, let me say that they are in support of this legislative amendment. However, when somebody makes a statement and gives evidence in relation to the accident or incident. They want to know whether it will become something which is self-incriminating. They don't want to be accused as a result of the evidence that they give. So will there be any safeguard for them? They don't want to be honest with you so as to assist with the investigation, and yet at the end of the day they will be prosecuted or punished. So it's their concern. I did ask them as to whether they had seen anything in the overseas framework. If we only find it here in this piece of regulation, I'm not sure whether similar safeguards will be given to a person who gives evidence. They have told me that they do get it in overseas regulations. I'm asking them to give us the information. Maybe Mr. Shum can give you the details. I just want to point out that for Annex 13, the spirit is such that when there is an investigation into the accidents or serious incidents, the purpose is to find out about the cause as well as ways to prevent the recurrence. Annex 13 has made it clear that it is not for the purpose of assigning blame. It isn't a criminal investigation. The main purpose is to find out the cause of the accidents or serious incidents so that the global aviation industry can learn from such a lesson. So in broad terms, the purpose of such investigation is not to prove whether somebody has done anything wrong. As to the ensuing criminal or civil actions, they are separate from this investigation. In fact, currently our investigations have also taken this into account. Mr. Shum. Mr. Lau has indeed answered the question. We have written down clearly the requirement of Annex 13. The only purpose of such investigation is to avoid accidents or serious incidents, and it is not to apportion blame or liability. So we have made it very clear. All right, point is noted. Yes, indeed. In Regulation 4, you have included the purpose of the investigation. But say, for example, upon completion of the investigation, the police would like to charge somebody. I want to know about the information given to the independent investigation. Can the witness concerned say that he refuses to give the information to the police and the police has to carry out the investigation afresh? Or will the information be referred to the police?
So we need to look at it from two levels. First, for accident investigation, well, the purpose of it is to learn from the experience so that the same mistake won't be repeated again. But if the police are to follow up, then this is another consideration in terms of law. So when we carry out the investigation, we are not saying that we will protect people from other sanctions. Well, I'm saying that if information or flight records are given to you, and then the police want to carry out a criminal investigation. So if they ask the investigation authority for such information, can the authority refuses because the authority only carries out investigation. It should not be giving information to other parties. And for Regulation 4 is quite macroscopic. It hasn't mentioned this point, that is whether the investigation information should be divulged. So who should keep the information? And is there a barrier? I can supplement. Now, for Annex 13, it provides a guidelines as to how the investigation should be carried out and how data should be protected. We are at stage 1 of amending the law. That is, we will now give the DGCA's investigation power to the CI. And as for the second stage, we will look at the whole guideline. So for the accident investigation, we just want to avoid another accident like that to happen again. And in the course of investigation, if certain information is gathered, and if the police want to get the information from the CI, then first, when we carry out the investigation, we collect information, and then we will have to write a report. And there are procedures which would include all the stakeholders affected by the investigation. So these people can give us feedback. So after the report is written, the stakeholders should have already given their views concerning the information we collect. Now, if that's information that we've considered but is not included in the report, for example, some recordings or video recordings, if other law enforcement agencies want to get those information from us, Annex 13 states that there must be a balance. That is, whether the provision of such information would be in public interest. Now, if there's an impact on public interest, then the CI would have to make a decision together with other independent authorities. It's not to be decided by the CI himself. So this is quite complicated, and at the second stage we will consider in greater details as to how that should be done. When will the second stage start? 2018-19. So it's also about these two pieces of legislation. That is Hong Kong's Civil Aviation Investigation of Accidents Amendment Regulation and Aviation Hong Kong Order. Well, I want to ask you a question about evidence. What's the present way of doing it? Now, of course, now the DGCA will carry out the investigation, and then there will be a report. In the report, a lot of things will be mentioned, and of course, the report is an open document. When the police carry out the investigation, they won't say that, well, you should give me all the information. They would ask you for a certain document. And that document might have been mentioned in the report. So I want to ask you this. Now you have an accident investigation report, and in the report a document is mentioned or certain evidence is mentioned, and the police ask you to give that particular document to them because they are carrying out a criminal investigation. So under such circumstances, what should you do? As far as I know, in terms of law, there are no clear stipulations concerning this, and so far the police have not asked us for investigation information which is not disclosed in the report. Well, I'm saying that if it's in the report, so for example, is in the annex or in the appendix, most of the regulators would not entertain such requests. Now, if something is mentioned in your investigation report, and if the police ask you for a relevant document, they are specifying they want a particular document, and that document is mentioned in the accident investigation report. But of course, you do not have the details of that particular document in the report. And the police, well, for example, if there is a very senior police officer who is in charge of a criminal investigation and he asks you for these documents which is mentioned in your investigation report. So are there rules as to how you should do? That is, whether you should give them the document or not. Now you are saying that stage 2 will commence next year. So what's the present practice? The existing practice is like this. The investigation information and data will not be disclosed. Even if the police asks for them, we will not give them to the police. The reports as to whether the reports will be made public is to be decided by the chief executive. However, if the police ask for the information, our established practice is that we won't give to them. Now, if in the report a document is mentioned and if the police ask you for that document, you wouldn't give it to them, right? Yes, that's our established practice. Mr. Yick. Now, the police ask you, you can resist. This is your established practice. Now, if I'm really carrying out a criminal investigation, and if you don't give that document to me, it doesn't matter because I'll go to the court for that. This is just a legal procedure. This is just a very normal procedure. Thank you, Chairman. Let me explain briefly. However, if you want more details, we may have to dig deeper. Now, we have to look at the police investigation and what ordinances are they invoking. The police may ask different parties to provide information. At present, the CAD's internal practice is that it won't provide investigation information. The police, as to whether the police request can override the CAD's practice, we will have to look at the relevant laws. Okay, I'm just asking about the ordinary practice in Hong Kong. Now, if the police wants to get certain information or documents from a certain party, and if the party resists, the police can go to the court for that, right? We can go back and look up the relevant information. So we really have to find out what the police are investigating. Would it be serious enough to override our normal practice? So you mean that normally you won't give them the information. The member wants to know that what if the police go to the court? Now, if the judge rules that you should give the documents to the police, then would you abide? So we are looking at it from a layman's perspective. Of course, if it's a court ruling, we have to respect that. My colleague was trying to tell you that we do not want to give people this impression. That is, for our investigation information, it can be given to anybody no matter what. So all the information will be kept confidential because we want witnesses to be frank with us. Now, if some law enforcement agencies want to get certain statements or documents from us, then we really have to look at the law. On the whole, of course, the court would have the final decision. So for this piece of legislation, we are trying to find out the facts. So we don't want mistakes to be repeated because this is about life and death. So for the involved pilot, if he's really made a mistake, I think he should be forthcoming. Otherwise, if your report cause suspicion, then there will be more problems. So we really need to know the facts. And after the investigation, if people think that the pilot is suspicious, then the court should be able to get more information. So for a responsible pilot, if he makes a mistake, he should admit it. Why should he be covering it up? Because he doesn't want other people to repeat the same mistake. I think, well, all this can be dealt with by the law. Legal advisor. Thank you, Chairman. Just now, members asked about the information collected during the investigation and whether the CI has the power to give the information to a third party. Members may want to look at Regulation 9. Certain powers are given to the CI. He can sign summons to call witnesses, and these witnesses can provide relevant information. And the CI can keep such information until the investigation is over. Members can look at Regulation 9A. These are the powers given to the present inspectors. As for the existing Regulation 9, whether it has given power to the investigator so that he can forward the information to a third party. Well, in the present regulation, there is no explicit inclusion of such a power. Now, if the police go to the court to apply for getting such documents, then we will have to look at the police request. Are they asking for some privileged documents? So if that is the case, the court will take into consideration that is whether that's a privileged document. Yes, thank you. Okay, I'll ask another round of questions. Here, you also mention accidents. In or over Hong Kong. So what's the definition of aerodrome in or over Hong Kong? Or are you talking about FIR? Mr. Shem? I think we are talking about the aerodrome in or over Hong Kong. If it's away from Hong Kong, then we are just an intelligence area, and we are to provide intelligence. So for aerodrome in or over Hong Kong is about the area that's over Hong Kong. Well, for the third runway, I think the problem would be bigger. Now for FIR, well, it's for the Hong Kong control towers to control the air traffic. And there are some areas which may not fall within this area, but still the Hong Kong air traffic control will provide service. As for the boundary between Hong Kong and the mainland, now there are areas like this. So for the third one-way FIR, will there be a new demarcation in the future? We don't know about that. Now, even in the basic law, it is stated that Hong Kong will provide air traffic service to Hong Kong's FIR. So if the FIR is to be redelineated, for example, if a certain part would then belong to the surface area of the mainland, then for the aerodrome over Hong Kong, if an accident happens, however, if at that moment the aircraft is in the FIR of the mainland, so would Hong Kong have to handle the to do the investigation? Now, because if this happens in Hong Kong, then Hong Kong would be in charge.
So can you answer this question? What will happen? Is my understanding correct? That is, even if part of the airspace of Hong Kong has been demarcated as the FIR of the mainland, as long as it is within the airspace of Hong Kong, our investigation office will be the lead investigator, right? Well, it is a hypothetical question. So we're talking about the question in a theoretical sense. Say, for example, if I hand over a certain part of the airspace to another party for air traffic controlling and vice versa, and you say that if there is an accident or a serious incident, I believe that this would have been covered in the cooperation agreement. Currently, we haven't got such a issue arising. For us to deal with such an issue, we will make sure that Hong Kong will have the power to take the lead in looking into such an accident or incident. You say that it hasn't happened, it is not happening. I don't think you are right. Well, Hong Kong is a small place. If we go to the south, I don't know whether part of it will be covered by the airspace of the Philippines or international airspace. If it is covered by the FIR of Hong Kong, so if something happens to this in the south, but it is within the FIR of Hong Kong, I want to know which place will be leading the investigation. Allow me to answer the question you talk about in or over Hong Kong, namely the airspace of Hong Kong. Well, if it has gone beyond the FIR, no, it is still within the Hong Kong FIR, within Hong Kong airspace. Well, the spirit of aviation accident investigation, we talk about the stage of occurrence. If it doesn't belong to any state, as to which place has got the ability and which state has the largest amount of information to carry out the investigation. Well, sometimes it will take more than one place, one region to coordinate their efforts and find out which authority is best placed to carry out the investigation. Say, for example, one may be better placed to do so, and it would also require the assistance of others. Maybe I haven't answered your question clearly, but this is the spirit. Yes, that's the spirit, but then we have to look at the provisions as well. Your wording is in or over Hong Kong. So where do we draw the line? The FIR isn't the airspace of Hong Kong. It isn't in or over Hong Kong. So I want to know about the boundary of the application. Airspace over Hong Kong, airspace above the land of Hong Kong. That is where we have, say, an island. Allow me to supplement. For the Hong Kong waters and the Hong Kong airspace, we may have to refer to Cap 1 for the definition. Here, if I may also refer to Regulation 3, we talk about over Hong Kong. We have to understand the term in the context of the place within Hong Kong and not so much about the FIR. Well, for aircraft registered in Hong Kong, even if it encounters an accident or incident outside of Hong Kong, in accordance with this regulation, the Chief Inspector will also be empowered to carry out the investigation. But this is confined to aircraft registered in Hong Kong. Members have referred to doubtful cases. I think it's a matter of aircraft not registered in Hong Kong, and if the aircraft is involved in an accident outside the airspace of Hong Kong, well, according to what has been said, it takes negotiation among relevant parties to make a decision. The regulation itself doesn't expressly provide for the powers to cover such a scenario. That is, for civil aircraft registers outside of Hong Kong, then this will be applicable only when the accident or only when the aircraft is in or over Hong Kong. Let's go back to Annex 13. When there is an accident, we have the stage of occurrence, which will be the priority investigating party. That is the place where the accident or the serious incident occur. Now, if the stage of occurrence, if you care to go to point 5.3 of Annex 13, it says that if it cannot be ascertained, let's pause. Which one are you referring to? Well, we have got a few spare copies. If you need, you can get a copy. Yes, please continue. I'm using the Chinese version. Well, 5.3, that is Chapter 5 of Annex 13, Paragraph 5.1 talks about the fact that the stage of occurrence must initiate an investigation into the occurrence and should be responsible for the undertaking of the investigation. In other words, when there is an accident or a serious incident and it occurs in one of the contracting parties to KO, then it's simple. The stage of occurrence will ask is Aviation Authority or the Independent Investigation Authority to carry out the investigation. If we read on and point 5.3, and it says that if it cannot be ascertained where the accident or serious incident occur, if it can, the stage of registry of the aircraft must carry out the necessary investigation into the accident or the serious incident. So our brief reply is that if we can identify the country where the accident or serious incident occur, then that will be the place, that will be the authority to carry out the investigation. If we can't ascertain the venue, the location, or it is within the in the international waters, then it will be the stage of registry. It's a bit complicated, what I'm going to say. Well, you have referred to the Hong Kong airspace. That's fine. For Article 130 of the Basic Law, it says that the Hong Kong SAR shall be responsible on its own for matters of routine business, etc., of civil aviation, including management of airports, provision of air traffic services within the FIR, and the discharge of other responsibilities allocated to it under the regional air navigation procedures of the ICAO. Now, currently, it is a fact that there is a discrepancy between our FIRs as well as our boundaries. We have one country, two systems. If something happens and if the FIR is that of the mainland, but in fact it is within the airspace of Hong Kong, then say, for example, the mainland may say that because we practice one country, two systems, so we're having one country, it is not the FIR of Hong Kong. Article 130 seeks to protect the FIR of Hong Kong. Now, if the Chinese authority says that despite the location of the accident is the airspace of Hong Kong, but then they would like to cite the principle of one country, two systems, since Hong Kong is not actually a sovereign state, though Hong Kong itself is a contracting party. But for Article 130, it refers to what happens within the FIR of Hong Kong. So do you understand my question? How are you going to handle this matter? So if an accident happens in the airspace of Hong Kong, but the mainland would like to look into it because Article 130, because here you talk about the land boundary, you may say that we have the safeguards in the Basic Law, but the Basic Law is using the term FIR. Well, Mr. Chairman, day in, day out, we have cooperation with our with the mainland counterparts of the CAD. Will they want to look into accidents or incidents within the airspace of Hong Kong or within the boundaries of Hong Kong? I don't think it has ever happened in the past, because we know and the mainland authorities know that we are managing different boundaries. I don't think they have ever tried to investigate into what is within our ambit, but it's for them or who is going to define the demarcation. And in Article 130, it's about our flight information region. Mr. Chairman, at least for those that should within our responsibility have not been looked into by them. They have not asked for that. Or sometimes it may be a matter of having joint responsibility. So, Mr. Chairman, I'm afraid I cannot give you a very specific answer. I can only talk about the concept. We do have a close cooperation with neighboring aviation authorities. When something happens, I'm sure we will all try to be cooperative and we'll try to solve the problem. We'll try to identify the cause of the case. Yes, this is understood. This is at the working level of resolving the problem. But what about the legal status? Yes, you are saying that has never happened. An accident is an accident. It hasn't been expected. If it does happen, what are you going to do? Mr. Chairman, it may involve legal issues or even the Basic Law. I'm afraid that I can't answer the question. I'm sorry about that. Would you give us time to go back to have a detailed analysis?
Thank you, Chairman. Just now you mentioned Article 130 of the Basic Law. So this is a constitutional requirement concerning Hong Kong's air navigation. Just now, the chairman read the Chinese version of the basic law, and let us look at the English version, Article 130.
The provision of air traffic services within the flight information region of the Hong Kong Special Administrative Region and the discharge of other responsibilities allocated to it under the regional air navigation procedures of the International Civil Aviation Organization.
Well, Chairman, you might have looked at this. The provision of air traffic services within the flight information region of the Hong Kong SAR. That is the FIR. And for members' information, what it deals with here does not include our present regulation. And this is about the air services agreement signed by Hong Kong with other countries. And this is to allow other civil aircrafts to make use of Hong Kong's international airport. This is my interpretation of Article 130. And members may also look at Cap 448B and the scope of the regulation. If you look at the marked up copy, it's about accidents in or over Hong Kong. So it is clearly defined that is within the territory of Hong Kong or above Hong Kong. I think the government has already given the chairman an answer. I just want to point out that for Article 130 of the Basic Law, whether the term FFL is applicable to this regulation. At the moment, I don't see the connection. Well, for Article 130, I'm not saying that is applicable here. However, it's about ICAO's Annex 13 because that's the FIR. As for Article 130, it also mentions the discharge of other responsibilities allocated to it under the regional air navigation procedures of the ICAO. This is also one of the responsibilities that has to be discharged. So that's why I asked my question. Well, can the government go back and think twice about my questions? You know my question very well, but I beg to differ concerning your answer. So Hong Kong is responsible for managing Hong Kong's SIR. If the incidents I cited occur, what would happen? Here you say that for the if an accident arises out of or in the occurs to a civil aircraft in or over Hong Kong, what would happen? Yes, we will go back and think in greater details. Okay, any other questions from members? If not, I'll ask another round of questions. Well, we may not be looking at each and every regulation now, but I have this question. Now, this regulation is applicable to civil aviation. So, for a military aircraft, if it enters Hong Kong legally, that is, it it has a plan to land in Hong Kong, and it's a military aircraft. And if any accident happens, would it be regarded as a civil aviation accident or what? Now for ICAO, we are talking about civil aviation only. So for this military aircraft, if it crashes with a civil aircraft, then what would happen? Now, if a civil aircraft is included, then the civil aviation regulations are applicable. It won't be that whenever a military aircraft is included, this is not applicable. So this is also about the basic law. So what if this is regarded as part of the national defense? There are two cases. Okay, supposedly that military aircraft comes into Hong Kong. Normally, it has followed all the procedures, and then it lands in Hong Kong. And an accident happened. It collides with a civil aircraft. So would this regulation be applicable? And secondly, if the military aircraft hasn't informed you. For example, in the South China Sea, the P-3s are flying all the time. If it enters Hong Kong's FIR in an unauthorized manner, and then it collides with a civil aircraft, then would this regulation be applicable? Now, if a civil aircraft is involved, well, maybe I need legal advice in this regard, but as far as I understand, if a civil aircraft is involved, this regulation is applicable. I'm afraid that if a military aircraft is involved, then someone would say that this is a military issue. And the Chinese government would regard it as part of its national defense, and you cannot carry out your investigation. Well, under the present regulation, any accidents involving involving civil aircraft, this regulation is applicable. Legal advisor, just now the chairman asked, now if an accident happens and it involves a civil aircraft and a military aircraft or state aircraft, when we look at the law, that is the Civil Aviation Investigation of Accidents Regulation, there is no regulation explicitly covering combined accidents. That is, accidents that involve state and civil aircrafts. The government the government would like to provide us with a supplementary paper on this, telling us whether the military will be working with you in the investigation if this kind of accident happens in or over Hong Kong. I think there is another possibility. We also have the PLA aircraft in Hong Kong, and if a PLA aircraft collides with a civil aircraft, now if it just involves their own aircraft, of course it's military, but what if it collides with a civil aircraft, or if an accident happens at the airport? Okay, so a PLA aircraft has a conflict or has a collision with a civil aircraft. What will happen? Okay, so please go back and think about this and then give me an answer. If these incidents occur, would these regulations still be applicable? Yes, we will do that. So I'll continue to ask questions. I have a more general question. How do you define the CVR? In your notice 160 under ANO 37, you say that. Now, just now we talked about the black box. And the beginning of the takeoff run to the end of the landing run. Well, for an accident, it may involve things happening on the land. That is, before an aircraft takes off, that is, the aircraft is taxiing out. When it's still on the runway, there may be a collision. And generally, from the engine starts, the aircraft would start recording, and it will only stop until the engine is turned off. So for the investigation, if the regulation is written this way, then there would be a missing gap. I think you know what I mean. Now, when the aircraft is taxiing out and there's a collision, then if it's written this way, then it can choose not to provide you with the black box information. Well, I'm not a pilot. As to when the CVR should be turned on, I'm not sure. But for the definition of the accidents, it's very broad. Now, here it says it's intended to fly, so it also includes the period before the starting of the engine. So when anybody is on an aircraft and the aircraft is ready for flight, then this period would also be included in the definition. So even if the engine hasn't started, it's also included. That's my understanding. So when somebody is on the craft until everybody's off the craft, then you can invoke this regulation for investigation, right? My question is, the requirements concerning the CVR 37.1, it says that it shall always be used from the beginning of the takeoff run to the end of the landing run. So that's a void. So for 37.1, it doesn't reflect what you really want to record. Chairman, that's another piece of legislation concerning the requirements for flights. So for an investigation, everything concerning the flights can be covered. Well, you asked when the CVR should be turned on. That is during taxi or when passengers are on board. Well, I cannot answer you right now, but I think your understanding is correct. There's another piece of legislation concerning aviation requirements. That is, before taking off, the CVR would have to be turned on. But when the plane is taxiing and when passengers are on board, would the CVR be turned on, then there may be a gap. So for accident investigation, it would not just look at the CVR, but the CVR is very important for an accident investigation. You have to know what's being said in the cockpit. So for an ordinary aircraft, there's always recording, and also there's a button which can erase everything. Now, supposedly, now I'm driving an aircraft and an accident happens on the land. That is before I take off. Well, when I know that, I can press that button and delete the recording.
Of course, the pilot will be questioned by the airline company, and he may be disciplined. But then, by erasing the record, nobody would know what has happened, and would it be against the law of Hong Kong? I see this as a loophole. I think you have to change it to read beginning of engine start and to the end of engine stop. That would have been more reasonable, and it is feasible, technically speaking. There won't be a problem. Nobody has to change any procedure, and still you can meet this requirement. And then we can plug the potential loophole, and we can close the gap. Now, if, say, there is an accident, an aircraft is taking off, another aircraft is crossing the taxiway, and then they heard the instructions, and there's a collision. Now, for the one taking off, then of course you require such information to be provided, but not so for the case of the aircraft still on the ground. Thank you, Chair, for your comment. I think your understanding is correct. For accident investigation, at our next stage, perhaps we'll have to check whether this particular part should be amended so as to enhance the strength of the investigation. Can you not do it now? Chair, allow me to add to the answer. As to the scenario that you referred to, probably is a question that you encounter on a daily basis at the front line. If we do want to change the arrangement, we need to carry out consultation. I don't think I will feel safe if we try to insert the change at this stage. Perhaps we can keep it for the second stage. Yes, we'll consider that. Mr. Kenneth Leung, the conversation has been very technical. For 37.1, we talk about the cockpit voice recorder from the beginning of the takeoff run to the end of the landing run. I don't know whether there is an authoritative interpretation when we talk about beginning of the takeoff run to the end of the landing run. So you move the aircraft to the end of the runway. Would it be regarded as the beginning of the takeoff run? The chair has referred to the possibility of a gap, but I'm not sure whether this is an authoritative interpretation or whether within the industry we will say that this is not part of the takeoff run. It is a matter of moving from the gate to the... No, that's not the takeoff run, not at all. Is that the beginning of the takeoff run? No. Within the industry, you will say that it is not, but then at law, the court may say that he doesn't agree with you. He may say that as soon as the gate of the terminal is closed and the aircraft is moving, then he will regard it as beginning of the takeoff run. We are not sure whether which one is the right interpretation. Mr. Chairman, here we are talking about specific aircraft operations. I'm afraid I may not be able to give a detailed answer. Even if we want to introduce a change, we want to consult the industry, like the airline companies as well as the pilots. So I maintain my position. When we start looking at the other parts of Annex 13, we will take this up as well. I haven't got other major issues at this moment. Can I check with members? Do you have other questions to ask? I suggest that we can ask our legal advisor if there is anything particular we want to look at, and then we can start the cross scrutiny. We may not be able to finish with the whole thing, but of course there's still some outstanding issues to be addressed arising from what we have asked a moment ago. Legal advisor. If there's nothing from the legal advisor, then we can start with the cross scrutiny. We can use the marked up copy. So please refer to paper 1262. Shall we adopt the Chinese version? Because after all, we are referring to ICAO-related documents. Sure. Yes, if we are ready, we can make a start. Yes, Mr. Chairman, let me sort of walk you through the clauses. First of all, commencement date. This is to tie in with the commencement of office of the Chief Inspector. We are now awaiting the approval of the FC. Once the money is available, we will start the global recruitment. We would like to do it within the year of 2017. We hope that the new Chief Inspector will report duty within this year, and then we will bring it into operation. Otherwise, the DG's powers will go to a post which is vacant. So we haven't yet appointed the day on which the regulation comes into operation. We'll have it being done on the same day that the Chief Inspector reports duty. No questions? Then interpretation. 2.1. The definition of accident will now be housed in 2A. We have added a new definition. Let's wait until we come to 2A. 2(1). Again, we're taking out the definition of Chief Inspector. Currently, it means that the Chief Inspector may investigate into civil aircraft accidents and civil aircraft serious incident. And since it is not just a matter of accidents, it should also cover serious incidents. So we are removing the word accidents from his job title. And the current definition includes any deputy chief inspector. The organization will be slimmer upon the reorganization. We don't think that we need to have a deputy chief inspector all the time. So when amended, chief inspector's definition will not include deputy chief inspector. When there is a vacancy, or if the chief inspector cannot discharge his duties for a prolonged period of time, will resort to administrative means to invite somebody to act his post. So legally, we are not going to get a deputy, but then in reality, we'll be resorting to administrative arrangements to have somebody who will be the acting chief inspector. No question? Then the definition of accident will be sort of amended because Annex 13 has a clearer sort of definition about incident. So the existing definition will be taken out to be replaced by the new definition recommended under Annex 13. We have a definition for incident. What about serious incident? Yes, indeed. We are going to adopt the version in Annex 13. You talk about it means an occurrence other than an accident. That would cover all sorts of incidents, right? Or incident means serious incidents. And that means they will be the subject matters of investigation. So, incident that affects or could affect the safety of the operation. Well, if you turn over the page, we have a definition for serious incident. Incident covers everything, but further down, the CI may look at all incidents, so they have to define what is meant by incident. Are we simply copying the definitions from Annex 13? Have we changed it at all? For accident and serious incident, basically we have copied from the annex, but of course for the Chinese version we have made some slight changes. Mr. Chairman, may I continue? Yes, please. We have changed the title of the Chief Inspector. We are removing the word accident. Are you referring to the marked up copy? Yes. Please also refer to the pagination, please. Page 3, Section 3. Sorry, I've only just got a copy of your marked up version. Page 0002. Sorry about that, Mr. Chairman. Let me continue. Let's continue with Accident Investigation Authority on page 0002. Yes, please. Accident Investigation Authority. Will investigate aircraft accidents and incidents, so we are sort of defining the scope of its work. Next, inspector in charge. That's in relation to the chief inspector as well as the operations officers under him. So we are just changing the title. And then investigation, we are giving a definition. It means that we will be carrying out an investigation under the regulations. So we're talking about the powers given.
Next is the definition of pilots in command. This is to make it clearer. We also have an aircraft operator. So pilots in command is the only person that can decide on the flying procedures, and he's the sole person in charge of the safe conduct of a flight. As for serious incidents, We copied this from Annex 13. I have some questions here. And here you said that when you talked about persons who have boarded a plane, so how about aircrafts that have not been boarded? There was an incident on an apron. Somebody forgot to wedge the wheels of an aircraft. There's nobody on the plane, but the aircraft slide on its own for 40 or 50 meters. It's quite a long distance. Fortunately, it didn't collide with any other aircraft, but then I asked the CAD. The CAD said that they would not look into it, and the HA would have to investigate the incident. However, to me, it's a potentially very dangerous occurrence. Now, there's nobody on the plane, and somebody forgot to wedge the wheel, and the brake was not turned on, so the plane slid. So on an apron, there can be uncontrolled aircraft. So would these aircraft be included here? Mr. Sham? So this is not in line with the definition of accidents in Annex 13. This is an MOR. As you said earlier, the CI and CAD would have a consensus. That is, if such incidents occur, how would the investigation be carried out and who should be doing it? Now, this is not complying with the definition of serious incident. It doesn't mean that the CI would not look into it. Now, for the TI, well, he would investigate into this incident, right? So for the incidents I mentioned just now, I don't know whether they filed a MOR, but there was nobody on the plane. So would it be possible that they didn't even have to file an MOR and CAD didn't look into it? They just asked HA to investigate. Well, this should be in line with the MOR definition. So the airline and the HA would report it to the CAD, and CAD would try to obtain more information from the stakeholders so that improvements can be made. As for the accidents you mentioned, I don't know how CAD replied to you because I was not personally involved. But if you describe such an incident to me, then this should be in line with the definition of MOR, and CAD should be reported to, and CAD will follow up. So even if HA is to investigate, CAD would know the result. So for the future CI, he would decide as to whether he would look into the case himself. Does he have the power to say that he's not going to look into it? If there is no change, then this would not be considered as a serious incident unless he thinks it's significant and he wants to investigate. But this aircraft slice, is it very serious? Well, the result can be, or the consequence can be serious. I think you really have to review it. According to the chairman, last time, CAD said that they would not investigate, and I think it's inappropriate because there may be two possibilities. First, the apron may be, there may be certain gradients in the apron, then the may be a problem. And now you're saying that a technician for gas to wedge the wheel, then I think the technician should also bear the responsibility. So you really have to investigate. Oh, you may find that it's not the pilot's problem. And now it's not wedged by a ground staff, so it may be the ground staff's mistake. So there must be a preliminary investigation trying to find out what the problem is and who should bear the responsibility. Now, well, for that incident, the aircraft was there overnight, and a wedge should be put at the wheel of the aircraft, and the aircraft was not put on brake. So normally, when an aircraft has nobody on it and it parks there, then the dish would not be put on brake, right? Yes. So what happened was that the aircraft slid, and some pilots discovered it and told the air traffic control tower. Then somebody was sent to stop the aircraft. So there's a huge potential danger because an aircraft is really big. When I wrote to ask about this, the answer I got was that the CAD said that because there was nobody on the aircraft, so AA should be responsible for the investigation. And I find it quite strange. Well, according to Mr. Sham, if an investigation is done and a report will be given to the CAD, then that would be better. But I don't know what actually was done. So for uncontrolled aircrafts on the ground, if things like what I said happened, I think investigation should be carried out. Yes, Chairman, I understand. Just now, Mr. Sham also made it clear. Well, so the so-called no investigation was just asking the stakeholders to look into it. As for MOR, we have 700 to 800 of them every year. And for minor incidents, we would ask the relevant airlines to investigate into it, and a report should be given to us. And if we are satisfied, then the incident is over. For no investigation, it doesn't mean that we don't even care about it. The investigation would just be carried out by another party. But Chairman, what you said is right. We will look into it. Okay, I have another question. It's about injury, hospitalization, burns, etc. Now, what if you smell some unidentified smell, or even the unidentified gas, or the gas may even be toxic? Well, Chairman, are you talking about page 0003, serious injury? Chairman, for these definitions, we also follow the Annex 13. It's very difficult to exhaust all the different scenarios in the law. The spirit is that if a passenger feels ill, then of course we would handle it. And for an investigation, we may not follow the serious incident investigation under this regulation. However, there will still be MORs, and so investigation will be carried out. Even if it's not here, it doesn't mean that we will turn a blind eye to it. We will use the existing mechanism, and there are different levels of handling different matters. Now, you're saying that when a person is injured, or here you say that requires more than 48 hours commencing within 7 days from the date on which the injury was received. So what about the inhalation of unidentified gas? It's not about bleeding or fracture. So a person is injured, and that injury may even be permanent. So after inhalation of the gas, he may be poisoned. He's not hospitalized. He may have been released from hospitals. And if there are 30 passengers on the plane suffering from this, it will be a huge problem, and so it's not classified as serious injury. Well, for D, now if you inhale certain toxic gas, and if the effect comes out after a month, then it would be covered by D because it's about injury to an internal organ. Yes, you are right. Thank you, Chairman. I would like to add a point. For serious incidents, is under the definition of accident. So the definition of serious incident is not narrowed. So serious injury is different from serious incident. Now we are on page 0004 of the marked up copy. And here are the definitions of accident. We also took reference from the definitions set out in Annex 13. No questions? Oh, 0005 is a continuation of the definitions of accident. Oh, due to the time constraints, I don't think we can finish the clause-by-clause examinations. And we also have asked you questions. The Pilot Association has also asked you questions, and they want to know more about the protection of personal data. They would write to you again. So the clerk would tell us the timetable. Thank you, Chairman. If the scrutiny period can be extended to the first day of next year's council meeting, that is the 11th of October, then after the scrutiny on the 6th of October, we will report to the House Committee. And if there's any CSA, they can be proposed before the 3rd of October. For our next meeting, we can have it on the 3rd of July, 10:45 a.m. Okay, we still have 2 minutes. Do we want to continue? Chairman, I have another meeting. Okay, then let's stop here and we will continue in the next meeting. Thank you.